Good morning and welcome from the Senior Law Day Collaborative. My name is Melinda Bellis and I'm an attorney in charge at Legal Services of the Hudson Valley. I am also a co-chair of the Senior Law Day Collaborative. I share this role with Elena Falcone from the Westchester Library System and Sarah Steckler of Washer Burstein. We are also ably assisted today by Bruce Siegel of Marketing Sense. You've joined us today to learn about Elder Law 101, everything you need to know about planning to preserve your assets. And we'll do that in just a few moments, but first let me tell you a little bit about the collaborative and the resources available to you. The collaborative is composed of more than 150 professionals who are all eager to bring authoritative information on legal, financial, and health topics to our county's older adults. We make available educational workshops throughout the year, as well as brief one-on-one consultations with collaborative professionals. You can connect with our resources and services through our website, seniorlawday.info. The site is a resource for information on legal and financial topics addressed by the collaborative. In fact, you can go there to watch the video recordings, prior webinars, or access printed reference materials, such as our annual updated Elder Law Q&A. And you can send us your questions on any topic of concern to older adults. Just look for the Ask Us button on the site. Send us your contact information and a rough outline of your question, and we'll work promptly to connect you with the needed expertise. And now a few points about the format in which we're working today. This Zoom video conferencing event is being recorded with the aim of posting the recording to the Senior Law Day site. And you as participants are muted. However, you can ask questions via the Q&A box on the bottom of your Zoom window. We may not be able to answer all questions that are posted, but unless you choose to ask anonymously, we'll work to follow up with you via email. And you could also save your question for that Ask Us button on the seniorlawday.info website. Now I'll turn this presentation over to today's presenter, Neil Rimsky, who's an elder law attorney and a partner at Cuddy and Fader. Neil.
Melinda, thank you. I very much appreciate the opportunity to address everyone, and Bruce, thank you for the help that you've provided also. I'm going to share my screen so that you can, where is it? I have a PowerPoint that I prepared. Here we go. So this is going to be an introduction to some of the basic concepts of elder law, elder care. We're going to begin with some very, very basic documents. The power of attorney, the healthcare proxy, and the living will. The power of attorney is the basic legal document to manage assets. Now, if something, God forbid, happens to any of you, and I hope it doesn't, but if it does, and there's no mechanism available, then no one's going to have access to your bank accounts, to your, no one can sign for you, and so on. And if something like that happens, they're going to end up in a guardianship proceeding to get access to your documents. So the power of attorney is an instrument that avoids all that, and it will allow you to give permission to someone or appoint them as your agent to manage your assets. New York does have a statutory form. It's actually been around for quite a while. It was revised probably in 1970 or around there. It became what's called a durable power of attorney. All the powers of attorney we prepare now are durable, which means that once you sign them, provided that you're competent to sign them, they remain effective despite the fact that you may later become incompetent. The statutory form has been revised several times since 2010. The most recent revision was this past June 13th. There was legislation that was passed in December. It became effective June 13th of 2021. There is a new statutory form which doesn't look like the ones that we've been signing since 2010. If you have a form that was properly executed in 2010, or at the time that you signed it was a proper statutory form, there is no need to redo it necessarily. This form that you created remains perfectly valid, and there's no urgency to go change anything. That being said, the banks and institutions are going to, in the next couple of years, be getting used to the new form. So just to make it easier for yourself, if you're going to be revising documents in the next couple of years, you might want to revise the power of attorney to the new form. Again, that doesn't mean what you executed before is a bad form or not recognizable or not approved. That's not true. It remains approved. But for the sake of ease, for the path of least resistance, if you have an opportunity and you want to bring your form up to, to the current form, that might be a good idea. Again, I mentioned before that you have the person signing it has to be competent. Now, what it doesn't mean that you have to have all the capacity that you once had. It just means that you have to be able to understand the concept that you're giving someone the power to manage your assets, and you have the judgmental capacity to do so, to understand what your assets are and to make that decision. So the fact that someone may be an early stage of dementia doesn't mean that they can't sign a power of attorney. If there are issues with capacity, my solution would always be let's get someone that really knows something about psychology or psychiatry to provide us a letter that says this person has the judgmental capacity to sign. You can appoint one agent, you can appoint multiple agents with the power of attorney. If you appoint more than one agent, then the form says to you, do you want everyone to act together? Do you want all the agents you appoint to act together, or can they act independently? You can have a primary agent or agents and a successor agent or successor agents. In each case, the same issue is going to be, if the successor agents are working and there's more than one successor agent, do they have to work together or can they work independently? The power of attorney, there's lots of basic statutory forms of statutory powers, like giving someone the right to pay your bills, giving someone a right to sell your house, giving some right to sell your car, to have signed contracts, to sign your applications for your changing residence or so on. So those are standard powers. But there are other powers that are possible with the power of attorney. So if someone can sell your house, what they've got to do is sell your house and take the money and put it into your bank account. There are other powers that would allow someone to actually make a gift. That is to take assets away from you. Now, that's a very unusual concept to consider. Most people don't want to consider that, but there may be opportunities and possibilities that it may make a lot of sense, either for estate planning purposes to balance your assets, or for healthcare planning purposes to allow someone to access government assistance, which we'll be talking about later. So if you want to consider those powers, if you want to consider the opportunity to do healthcare planning at a later point in time, then when you sign the power of attorney, you should consider having the modified powers that include the possible gifting power. And again, you can limit that. You can say, I can make gifts to my spouse, to my kids. You can limit to who the gifts were made. So you can be very careful. And frankly, if you have more than one agent, it would always be my recommendation that, particularly if you're using the gifting provision, that they all act together. So that you avoid the possibility of one person acting alone and modifying, and in effect, modifying your estate plan by removing assets from you. A power of attorney has to be signed before a notary, and the current form requires there be two witnesses. Witnesses cannot be agents. They shouldn't be related to you. They shouldn't be named in the power of attorney at all. The notary can also be a witness. The statute specifically provides that. The form itself, as it has since 2010, requires that the agent sign an affidavit. They cannot use the power of attorney without signing the affidavit. The affidavit basically says, I'm going to act on behalf of you, the person that's giving me the power. And even if they have the gifting opportunity, that they're going to do it with you in mind, and they're going to, so that the actions they take will be for your benefit and for the benefit of your family, things you would want them to do. A power of attorney, the basic form is effective when it's signed. So when you sign it, the agents can actually use it. There has been in the past what's called the springing power. There had been for a while a statutory form of springing power. It is no longer one of the statutory forms. It stopped being that in about 2009. The reason that the springing form is no longer one of the basic statutory forms is it created problems, because the springing form said, well, when I become incapacitated, and you need the two doctors to certify that you're incapacitated. The problem was you ended up in court in many of those cases. The purpose of a power of attorney is to avoid going into court. So people found that the statutory power of attorney that provided for, for acting in the future, the springing power, caused a lot of issues. So we can, to this day, modify the standard form to include springing powers. But we should understand that if you insist upon that there are some basic issues with that. And that's why it is no longer one of the standard forms. The next document is the healthcare proxy, which is the designation of an agent to make healthcare decisions. The power of attorney is for assets. And in New York State, the healthcare proxy, other states have a power of attorney for healthcare designation. New York doesn't have that. We have the healthcare proxy. There is a New York statutory form. It's very simple. It's one page. I've always described it as almost idiotically simple, and I like that in this case. And in my judgment, attorneys shouldn't be Shakespeare and try and write their own form. These things are used in an emergency situation. So you're in the hospital and someone has to make a decision. And you want the doctor to, you don't want the doctor to have to read it and send it to their counsel at the hospital and to try and interpret it. The basic form, again, it's idiotically simple. You appoint someone, here's their name, here's their telephone number, here's their address, and there's a substitute agent that you can have. Here's their name, here's their telephone number. You need someone to act quickly. The less they have to read, the less they have to interpret, the better off you are. So the idiotically simple form is good. The New York form is easily recognized. Everyone knows it. It's very simple. It's effective. So I would most definitely use the New York statutory form. You can indicate on the form, there's a space that says that does your agent know anything about your wishes about nutrition and hydration? It's been my custom to always say that my agent knows my wishes about nutrition and hydration, and we'll get to some of the details about that later. The form, it requires two witnesses. Again, the witnesses should not be the agents. They shouldn't be related to you. They should be independent persons. The third document is a living will. Sometimes some people will call it a healthcare declaration. There is no statutory form, but a living will is recognized in New York State. Now here, since there is no statutory form, this is where you set forth your wishes about nutrition and hydration. My preference is the healthcare proxy says my agent knows my wishes. If there are questions as to what those wishes are, you have a living will that the agent can pull out and say, okay, he doesn't or she doesn't want extraordinary measures taken to implement nutrition and hydration under the certain circumstances. And in most cases, the certain circumstances are that the person will never return to any form of functioning sentient life. That's a very conservative approach, but that's what many people wish. And again, I much prefer, and I would recommend that you do not mix the healthcare proxy with the power of attorney. The less someone has to read, the better off that you're going to be. The living will is something, the healthcare declaration is something you keep separate, and if questions ever arise as to what your wishes are, they can pull out the living will at that time. The proxy, the hospitals will only stabilize you if there's anything that needs permission, even setting a broken bone, unless it's required to actually stabilize you. They won't do it without permission. So they're going to go to the healthcare proxy. So even for minor procedures, they're going to go to the healthcare proxy. You don't need to confuse them with nutrition and hydration information, except in extraordinary circumstances. So keep it separate. That's my personal recommendation.
Neil,
Yeah.
excuse me. Someone just asked how often it needs to be signed. One hospital with which I am affiliated wants one done every year.
It is not necessary to be done every year at all. The form itself has a provision of when you want this to expire, so most people would leave that blank. If the hospital wants it, that's their particular custom, and there's no harm in that necessarily, but I am sure that they would also recognize that was done more than a year. So it's a recommendation so that it keeps you up to date and makes you think about it again. But there's nothing in the statute that would require that it be redone. You have the ability in any time to revoke a healthcare proxy, as you can revoke a power of attorney at any time.
Thank you.
Okay. Let's talk about medical care. And when we talk about medical care, we got to distinguish between skilled care and custodial care. Skilled care is you need a doctor, you need a nurse, hospital care. When you buy health insurance, when you have Medicare, and we'll talk about that later, that's skilled care. So if you're going to a hospital and you need a procedure done, that's skilled care. Custodial care is something different. It does not require a nurse. It does not require a doctor. It's someone to take care of your basic needs, your activities of daily living. That's custodial care. And we're going to talk about the different types of programs that are available to provide for the cost of those care. So let's start with skilled care. So the insurance, the health, yeah.
I'm sorry, it might just some follow-up questions on the healthcare proxy. Someone said, are these healthcare proxies supposed to be kept at local hospitals?
It's a very good idea when you sign a healthcare proxy to give a copy to your doctor, to share a copy with the hospital, to share. I mean, it should be on record. So if you can now, if you're driving across the country, obviously that's not going to happen. So you might want to have a copy available or a reduced copy available with you. But if I live in White Plains, people at White Plains Hospital have a copy of my healthcare proxy. The doctors that I see regularly all have a copy of my healthcare proxy. So I have scanned it and I have sent it to them. So it's a good idea to actually do that. Yeah.
And we received a question asking if these documents could be added to a smartphone's photos.
I don't see why not. You don't need an original for a healthcare proxy. A copy is perfectly good. There's no reason you couldn't keep it on your smartphone, so it's available. It's a good idea.
So two more, and you know, if it's better to leave for the end, just let me know. One person's asking about the procedure to revoke a power of attorney in a healthcare proxy. And then there's also a question asking if the proxy provides an agent access to medical information such as HIPAA's.
We always, I'm glad you mentioned that because I forgot to talk about HIPAA, is we always do a form. You can either add language to the healthcare proxy that is HIPAA language. The truth is the actual form itself mentions HIPAA. So technically you don't even need that, but it's probably a good practice either to have a separate form or to incorporate form for HIPAA into the healthcare proxy itself. But technically, and you don't really need it, but it's a good idea to have it. What was the second question?
About revoking a POA or a healthcare proxy.
You can rip them up and sign new ones. But if you rip them up and other people have a copy of them, you've got to let them know that you've changed. So particularly with a power of attorney, the financial institutions are going to be protected if you've changed it and you've ripped up the power of attorney and you don't tell your bank, and your old agent goes to the bank and they don't know about it, they're going to be protected. Now, so even though you can rip it up and you can change your agent at any time, if you have an account at Citibank and they have your old power of attorney, you've got to notify them that you've changed.
Thank you.
Okay. Skilled care. This is the type of care for which you and I have been buying insurance all of our lives when it's been customary since I've been, working, that your employer provides a level of insurance. The type of insurance that I've always had is what provides skilled care. As I turned 65, I was eligible for Medicare Parts A and B, and Part D. Part D, of course, is for the drugs. So it is a good idea, even if you have Medicare A and if you have Medicare B, to have a Medicare supplement policy, because Medicare, there are co-insurance provisions, there are deductibles and so on that would be picked up by the Medicare supplement policy, should be picked up by a Medicare supplement policy. There are, I think, 8 or 9 Medicare supplement policies that are generally available, A through F or A through J, I forget what it is now, but they all have to have, every A policy has to have certain provisions, every B policy has to have certain provisions. There are different underwriters that provide that, and they may charge different amounts for it, but the policies should be essentially the same. Part D, of course, is for drugs, and there's a separate charge for that. If you are, so if you have the ability to get a Medicare supplement policy, I certainly have one, and I would more than recommend that everyone have one. There is something called the Medicare Advantage Plan, which is Part C. It's the same thing. Part C is Medicare Advantage Plan, where you don't necessarily have to pay extra. So what happens is that under the Medicare Advantage plans, they take a portion of your Social Security that goes towards your health care and put that towards the Medicare Advantage Plan. And so you don't necessarily pay for that. The disadvantage to the Medicare Advantage Plan is that you don't have the same flexibility. It's sort of the same thing as an HMO, a health maintenance organization, where you may be limited who the providers are. Now, if you're happy that all your providers are participating in a certain Medicare Advantage plan, that may be perfectly adequate for you. You should understand that could change at any point in time, and certainly it could change from year to year. But you should be aware of the fact that the supplements themselves have a lot more flexibility than the Medicare Advantage plans. For custodial care, your Medicare, under no circumstances, it's not going to pay for any custodial care. So there are provisions in Medicare and with the Medicare supplement to pay for, say, nursing home care, but they're not paying for long-term nursing home care. If you're hospitalized for 3 or more days and you're discharged for what they call subacute care, now it used to be called rehabilitation, it's the same thing. And you're admitted to a nursing home either directly from a hospital after being there for 3 full days, and the level of care you require is skilled care, which is rehabilitation, physical therapy, occupational therapy, and so on, then Medicare will cover that, but not because it's long-term care, but because it's skilled care. Medicare will cover up to 100 days. The first 20 days, Medicare pays everything. The last 80 days, there's going to be a co-insurance requirement, which is not small, but your Medicare supplement policy, which we just talked about, should pick up the co-insurance for the last 80 days. For paying for custodial care, it's extremely costly. Home care can easily run $6,000 or $7,000 a month. Institutional care, nursing home care around here, we're talking at least $15,000 to $20,000 a month, and some came up to $25,000 a month for some facilities that were within a 25-mile radius of Westchester County. So if it's going to be, your choices are private pay. Long-term care insurance is a form of private pay. So if you have long-term care insurance, that's great. In order to qualify for long-term care insurance, you have to have, for the triggered long-term care insurance, you usually have to be able to not perform 2 or 3 activities of daily living. The problem with long-term care insurance is it's been very, very costly over the years. And although many people have been hoping that long-term care insurance would be the solution that reduces all the reliance upon Medicaid, that really hasn't happened. That may be, unfortunately, unfortunate, but it is true. I would encourage you that people that you may know, if you're considering long-term care insurance, while you can still get it, it's a good idea. It is costly, but long-term care is costly. If you're going to have to rely upon government assistance, the only programs available for custodial care for government assistance are Medicaid programs. They're means-tested programs. So they are income sensitive and they are asset sensitive. And we're going to talk about that now. Medicaid offers programs for both home-based care, which is called community care, and there's nursing home care. It's also referred to as institutional care. Just so you understand that institutional means nursing home. A hospital you may think of as an institution. It's not institutional care for Medicaid. It's home-based care. So the only thing that institutional care applies to for Medicaid purposes is going to be nursing home care. But again, Medicaid is available for community-based care also. But there are very strict financial eligibility limitations. For an individual, and Medicaid separates income from assets. Income, is your Social Security, your pension. It may be your required minimum distributions on your IRA. It can be the interest that you receive from investments. You're allowed, the limit in New York State right now is $884 a month plus $20 of which is called the $20 disregard. So it's just over $900 a month. That's it. If your income is above that, you're technically not eligible. We're going to talk about ways around that, but you're technically not eligible until you spend the excess income down on your medical care. So if your income is $1,200 a month and you're only allowed to keep $900 a month, in order for Medicaid to start paying for your care, you have to spend the first $300 of your income, spend that down to the Medicaid level, and then Medicaid will start to pay. Again, there's a way around that. We're going to talk about that, but that's what the basic rule is. The resource level is $15,900 for an individual. Now, that's not a whole lot of money you're allowed to have, but that's what the rule is. Some assets, most of your bank accounts and so on, they're countable assets. Most of your brokerage accounts are countable assets. There are things that are not countable assets, and those are your home. As long as you're living there or a spouse lives there, it's not a countable asset. Or if there is a disabled child living there, it is not a countable asset. Interestingly enough, also an IRA or any kind of qualified plan, 401k, for example, if it is in pay status, which it has to be after a certain period of time. Certainly your IRAs have to be in pay status the calendar year after you turn 70 and a half. But if you have a qualified plan or an IRA and it is in pay status, and theoretically it's supposed to have regular distributions. So, and I'll tell you what that means. Once it's in that pay status with regular distributions, that asset disappears. It's not, in other words, it is not counted. So you could have a $2 million IRA or multiple accounts that are IRAs. If each of those accounts is in pay status and each of them has regular monthly distributions, that will no longer be a accountable resource. It's not going to count. Now, we talk about distributions before, it will add to the monthly income. So now we're going to talk about ways you can deal with monthly income issues. So let's stick with that for a second. So, and you'll see on the screen, the second bullet point that's mentioned is the pool income trust. So most people can't live on $900 a month. Most people have rent that's more than $900 a month, or they have a mortgage, or they have maintenance on their co-op or on their condominium, or their home here, or their home costs are way above $900 a month. So they can't live on $900 a month. So under the Medicaid rules, if you're required to spend down to $900 a month, there's no way you can maintain yourself in the community. To get around that, you can participate in what's called a pooled income trust, which is it's a trust. They are existing trusts. They're run by not-for-profit entities. Around New York State, there are a bunch of them around New York State. What happens when you participate in these trusts, what you do is you sign an agreement that it's a participatory agreement. You fill out information about yourself. They're usually very simple forms, and you can see them. I can tell you where you can get them online. And you say, I'd like to participate in this pooled income trust. So you tell them, okay, my income is $2,000 a month. I'm only allowed to keep 900. So every month, I'm going to take the excess income, which is $1,100 a month in my hypothetical. I'm going to send that money up to the pooled income trust. And well, what good does that do? You can now tell the pooled income trust, you've got that extra income that I've got. They will take a small fee, and it's usually a very, very modest fee. But you can say to them, I need you to pay my expenses. They will pay your rent. They will pay your credit card. They won't pay my credit card. They won't pay someone else's credit card. They won't pay someone else's charges. So they will pay your charges. So, but when you show the pool trust that, yes, this is my American Express bill, and this is my charge from for some shirts I bought, and they're from me, they will pay those charges. So that's how you can use the pooled income trust to pay household expenses that you could otherwise not pay if you did nothing to protect your income. So there may be questions about that later, but let me go back to some of the other issues. And that is, I said before that you're not eligible until your assets are at or below, countable assets are at or below $15,900. So most people have more than that. So the question is, can you give those assets away? And the answer had been for community-based care up until the law changed in April of 2020. That yes, you could give assets away and it would not cause any problem when you made a Medicaid application. In April of 2020, there was a statutory change in New York, which theoretically became effective October 1 of 2020. And all of a sudden, there was a transfer penalty, a period of an ineligibility that was imposed for gifts that you made, giving money away to people, and that would be uncompensated gifts. So if you buy something, if you buy a car and you get a car for that, that's not an uncompensated gift. You've got something in exchange. But if you take that car and you give it away, or you take some cash and you give it away, that would be a gift that could render you ineligible. So it was supposed to take effect for any applications made on or after October 1 of 2020. That has not yet been implemented. So the law remains effective as of now. So if you made gifts on or after October 1 of 2020, when the statute is actually implemented, those gifts can and will cause you to be ineligible for Medicaid home care for a period of time. There had never been a look-back period for home care. There's a 30-month look-back period now. So if you make an application, once they implement this, you're going to have to provide bank statements and copies of all your documentation for the last 30 months. Again, it has not been implemented yet, and the information that I have as late as today, is it will not be implemented until the earliest of July of 2022. So that's where we are today. Again, if you make a gift now and you actually make the application before July of 2022, you're going to be under the old rules, which means the gift will not matter. If you wait until after July of 2022, you run the risk that it's going to create a period of ineligibility. The other thing that I want to mention, which is very important for home care, is if you're going to be applying for Medicaid home care for home health aides and personal care aides, you may end up with an agency. There are some people that don't like using agencies. They may have had a person or maybe even a child or someone that they really like a lot, and maybe an aid that they've been using for a while, and they'd like to keep that aid. So there is a program called the Consumer Directed Personal Assistance Program that allows you to have Medicaid to pay for aids of your choice. You should be aware of that. There's some complications with that, but you should be aware that that program exists. Now let's switch to institutional care. Now there's been a transfer penalty for institutional care from the very beginning. It's basic federal law. There has been a 5-year look back, a 60-month look back. So when you make an application for Medicaid for institutional care, you've got to provide bank statements from every account that you've had, and if you're married, that your spouse has, for the last 60 months from the date that you want Medicaid to pick it up. So if you want Medicaid to pick up something in January of 2022, you've got to go back 5 years and provide every statement and tax returns for that entire period of time. There are some exemptions to the rule that when you give money away, it's going to create a period of ineligibility. So these are what we call exempt transfers, and they are, you can give as much money to a spouse as you want. There is no period of ineligibility. You can give as much money to a disabled child as you want. There is no period of ineligibility. You can give as much money as you want to a trust for the sole benefit of a disabled child. There's no period of ineligibility. There's a special exemption for the homestead. There are 2 exemptions. The primary one that people use a lot is called the caretaker child. So if there's an adult child that has been residing with you and providing support, it doesn't have to be care itself, it's support that enables you to remain home for the period of 2 years immediately prior to your entry to a nursing home and applying for Medicaid. So for during that period, if the child had been residing there continuously for 2 years, you can give the home to the child, no matter what it's worth, whatever the value is, you can give that to the child. That's an exempt transfer. It's designed to encourage adult children to take care of their parents. And there's also an exemption for siblings with an equity interest. I believe the sibling has to have the equity interest for a year. But the primary homestead exemption that people rely upon the most is the caretaker child exemption. There's also special rules regarding spouses, which we're not going to get into a lot, but I just want to mention to you. They do not require both spouses to spend down to $15,900. So the community spouse, so the terminology that's used is the person that's going into the nursing home, since these are institutional rules, not yet applicable to the, they'd be used for home care, but they're not yet applicable to the, they haven't been worked into the change in the law. For a community spouse, you're allowed to have a certain amount of assets, and the community spouse is allowed to have a certain amount of income. So the asset level really is the community spouse is allowed to have a certain amount of assets, which are 1/2 of the total assets of the combined person going to the nursing home and the spouse, from somewhere between $74,820 and $130,000. So if half of the assets fit into that group and the income is below $3,200 a month approximately, then the nursing home person is automatically eligible despite the fact that the spouse has more than $15,900. In most cases, spouses have more than $130,000 of available resources. And that doesn't mean that the person going to the nursing home is ineligible. But there's something called the spousal refusal. So if one of the spouses is going to go to a nursing home and the assets, let's say $200,000 or $300,000 in addition to your home, which is exempt. So the institution, the person that's going to the nursing home, give all that extra resources to their spouse. That's an exempt transfer. The spouse can say, I can't afford to pay for my husband or my wife, whoever is going to the nursing home. And with the spousal refusal, the institutionalized spouse will get Medicaid. So there is an opportunity to get Medicaid even if the assets and income exceed the spousal rules. The problem with the spousal rules is when you give all that extra money to the spouse, and the spouse says, I'm not going to pay, New York State's going to start paying. New York State may not be particularly happy about that and may say, hey, we're paying what is your wife or your husband's obligation. We're not happy about that. We're going to ask them to contribute something. And sometimes they do ask the refusing spouse to contribute something. And if the refusing spouse refuses to contribute, they could, under certain circumstances, sue the non-compliant spouse for support. That's called the spousal support suit. There have been times when the Department of Social Services has been active, and there are times when the Department of Social Services has not been terribly active about it. But when you sign a spousal refusal, whoever's signing it should be aware of the possibility of a spousal support suit at some later point in time.
Neil, one question.
Please.
For community Medicaid, the 30-month look-back period will not be implemented until at least July 2022. Is that correct?
That's what I understand as of today.
Thank you.
There was an email that went out from the Bar Association today that said that that's what the current date is. Yeah. Okay. So we've talked about community-based care, and we've talked about nursing home care. The truth today is, I started practicing elder care about 1990, and there's a very different landscape than there was then. Back then, there was some level of home care, and there was nursing home care. There were very, very few intermediate levels of care. That's not even close to being true anymore. There are many independent living facilities available. There are many assisted living facilities available. The independent living is, doesn't offer, it maybe offers housekeeping, but there's not a whole lot of medical, there really is no medical care at the independent living. The assisted living offers some level of support. Usually there's meals provided. There may be housekeeping. They may offer some aides coming in for a certain level of care. Usually with assisted living, if the basic charge in this area, it tends to be between $6,000 and $9,000 a month for the basic charge. You can layer additional levels of care on top of that. So if you need aides, you can remain in the assisted living facility, but you have to pay more for it. So it's often the case that the actual care at an assisted living facility in Westchester County is going to be $10,000 or more. There's a third type of institution which really combines the independent living, the assisted living, and nursing home care. It's called continuing care retirement community, where all three levels of care are offered either in the same campus or by the same institution. On New York, there are not many examples of that in New York State. There are some. Kendall is an example. Jewish Home and Hospital has some CCRCs, and there are some others in the area. I don't remember exactly the names right now, but there are not many continuing care communities because New York State has very strict requirements, requiring that whoever the developers are have a sinking fund that can be very expensive, and that's a disincentive for the developers to have CCRCs in this area. When you go to New Jersey and you go to Connecticut, you'll see a lot more continuing care communities than you will here. They exist, but again, there's not many of them around. And there are different contracts that are available for CCRCs that's an entire separate discussion, but it's something that I would want to make you aware of. There are so what we're talking about so far are models that everyone that are, when you walk around the street, you'll see assisted living facilities. Some other approaches that are out there, the concept of a naturally occurring retirement community is actually not new, but it's not something people necessarily think about. There are buildings in Westchester County and in New York State and around the country, these NORCs, as they're known. They were buildings that were not designed as senior facilities. The primordial one is on 7th Avenue. It used to be the United Ladies Garment Workers Union. Over on the 7th Avenue and 17th Street, there are 10 or so buildings which were not designed as senior residences. Over time, people aged out, and they started a very smart concept of using those buildings by making some of the facilities available for seniors, and working with New York City so that they were able to provide care to a large number of people at a relatively modest cost. So that is NORCs. They do exist in Westchester County. They're supported by Westchester County, by the Department of the Aging. And frankly, in my judgment, a lot of what will be happening in the future will, if it's going to be successful at all, it's going to be what I would refer to as a public-private partnership. In other words, some of the money is going to be private and some of the money is going to be public. And I think we'll see a lot more of that developing over time. The next item I wanted to mention is the village concept. It's not from the TV commercials you see of these places in Florida that's called the villages. It's an idea that where people can participate in a quote unquote village. It's a concept. You can sign up for it. There's usually an annual charge for it. They're all over Westchester County. There's one in Larchmont, there's Scarsdale. They're all over the area. There's hundreds of them around the United States for a modest fee, and usually that can be waived if the person can't afford it. You can get services. There can be transportation services provided. They can make arrangements to visit museums together. They can make recommendations on this contractor is good. They can make a recommendation on this accountant's good, etc. So it's a very good idea. It's a way to get seniors to participate together. It's a way to use resources of a community in a way that's advantageous to a large number of people at a very, very modest cost. So as you can see, I'm a big supporter of the idea of the village concept. We now have telemedicine, which has also been a game changer in terms of keeping people away from hospitals after they're discharged. One of the big problems has been and remains that people that are in hospitals often end up back in hospitals. There are lots of opportunities now for telemedicine, where you can communicate with doctors either virtually with a computer or by telephone. They can manage your medicines like that. They can ask you questions like that. They can check your temperature like that. So that there's an opportunity, and it's worked well. It has reduced public costs by a great deal, and has allowed a lot of people to remain in the community when they would have at some point in time had to go back into the hospital. And the final thing I wanted to mention in terms of the elder care concept is there's a program that's called the Greenhouse Small Home Program. It's in nursing homes, but it's a non-traditional approach. The only nursing home that I know that has greenhouse around here is Sarah Newman. And one of their buildings, there's these pods. There are 5 or 6 people that live in a pod. They all have their own units. There's a person that supervises it. They have their own meals that are cooked. It's a much better environment. It's a much more home-like environment. So it is available. It's available around the country. I really applaud those institutions that have made a real effort to have nursing homes more of a home-like environment. So a place like Sarah Newman does have that. They have the traditional nursing home. They also have the greenhouse, these pods. So if you know someone that's interested in, it's really a terrific opportunity. I just wanted to mention some estate planning concepts. And the 2 primary things I just want to very quickly mention are last wills and testaments and revocable trusts. And and what the differences of them are. Obviously, a last will and testament is something that you sign. It has to be presented to court. It has to go through probate. And you've heard stories about probate. In some jurisdictions, probate is expensive. That's not necessarily true in New York State. That's not been my experience at all. It's really pretty simple. There are some situations where you shouldn't think about probate, and that is since probate requires contacting your heirs. So if someone has no heirs, and that happens, Holocaust survivors have no heirs. In many cases, you don't want to probate because someone's going to have to find your heirs, and they could have died in Europe years ago. Or since you notify heirs and your heirs have an opportunity to challenge, if you have a litigious family, and people have that, And you know there's a child you haven't spoken to for the last 20 years, and that child's going to be vicious and is going to start problems. You don't want to probate. In many cases, probate is very simple. All the people that are heirs, which are usually a spouse and kids, sign off on it. And I'd say 95% of the cases that I've seen, a last will and testament is frankly a lot less costly, and it's an easy way to go. I know that's not what you're going to hear on the radio and the television, but I'm telling you what my experience is. There is and you will hear about revocable trusts. We do a lot of revocable trusts to avoid probate, and some people want to avoid probate. One thing you should be aware of, particularly when we're talking about elder care, and that's also essential that you understand this, is that New York State and federal law is not happy with people using trusts as a way to protect their assets. So if you're going to be using a trust to protect assets for Medicaid purposes, remember we talked about making gifts before, you can use a certain type of a trust as a way to get your assets out, to transfer your assets so that Medicaid can't touch them. Now, for a revocable trust, you should understand, is completely worthless for that purpose. And even after you die, if you have a revocable trust that says, when I die, I want my trustees to take care of my wife or my spouse, the revocable trust is worthless for that purpose. All the assets that are in that trust are going to be available assets, will offer no protection whatsoever. If you have a last will and testament, so the law is totally different. Whereas lifetime trusts are not New York doesn't like lifetime trusts. For a last will and testament, if your will says, when I die, my money is going into a trust for my wife or my spouse, and my trustees have the discretion to use that, the assets in that trust are sacrosanct. No one can touch them. So even though the provisions are the same, if you have a trust in your last will and testament, the assets for healthcare purposes will be protected. If you do it in a revocable lifetime trust, the assets will not be protected. So you just should be aware of that. So if you're doing all this to avoid probate, that's fine, but you should understand the fact that if Medicaid is an issue or could be an issue at some point in time, you should reconsider what you're doing. And with that, I have finished the formal part of my presentation. I'm hopefully haven't taken too much time, and there may be some additional questions. I'm more than happy to entertain your additional questions. Melissa, are there anything?
Some interest in irrevocable trusts, and do you recommend putting one's house in an irrevocable trust? Also a question, if someone protests a will, are they out of the will?
All right, let's take one question at a time. If you're thinking of doing something to protect your house, it is true. I mentioned before that the house is not an available resource, but if you do nothing to protect it when you die and it remains part of your estate, the Department of Social Services can recover against it because it will be part of your probate estate. So if you want to do something to protect it and to have the house available, yes, putting it into an irrevocable trust, a certain type of irrevocable trust can be a very good idea. You have to be aware of the fact that when you do something like that, you are absolutely creating for nursing home care a 5-year period of ineligibility. You will not get Medicaid to pay for nursing home care within 5 years if you put something the size of a house, the value of a house into an irrevocable trust. So yes, it's a good idea. Be careful when you do it, because you could be doing something to protect your assets, but at the same time, you could be rendering yourself ineligible for care. So if you're going to do something like that, you should most certainly make sure that outside of the trust, you retain assets sufficient to pay for 5 years of institutional care. But the irrevocable trust is a good idea for any number of reasons. If it's done properly a certain way, then the people that will inherit the house at a stepped-up basis, which means in English that when they sell the house, they won't pay capital gains on it. If they inherit the house when you die, if it's an inheritance, the basis in the house, if you bought it for $200,000 and it's now worth $1 million, if you sell it, there's a gain. But if your heirs inherit the house when you die, the basis becomes the fair market value when you die. So it's called a step up in basis. So the house that had been bought for 200, if you die and it's valued at $1 million, the basis of your heirs is now $1 million. And if they sell the house, there will be no capital gain. So the trust can be used for that purpose. Also, if you're going to be selling the house when you're alive, and you do the house and you do the trust a certain way, then you will retain the $250,000 non-recognition of capital gains with the properly drafted irrevocable trust. So yes, it's a good idea, but be careful with it. What was the second question, Melissa?
If someone protests a will, are they out of the will?
The answer is no, unless there's something called an interorum clause that says anyone that protests my estate and will no longer participate in it, the kids are no longer going to participate in it, and if I did any other documents like a trust on the side or whatever I've got, they're out. That's called an interorum clause. And it even says that if you challenge the interorum clause, you're out. So there's a clause that's specifically designed to keep people out, but unless that's in the will, whoever challenges will still participate.
What kind of trust should be used for community Medicaid purposes?
If for community, if you're looking for to protect assets for community Medicaid or institutional Medicaid, you need the irrevocable trust. Any trust that under any circumstances, if the trustees have any discretion to return trust principal to the person that set up the trust under any circumstances, the trust is absolutely worthless. So even if you have a trust that says that if my son, who is now 60 years old, ever goes to elementary school, my trustees can pay for their books. So it's ridiculous. It's not going to happen. But putting that language in, it's a hypothetical to show you how ridiculous it is. But if there's any possibility of the trustee returning any principal to the grantor, the person that set up the trust is absolutely worthless. So the trusts have to be very restrictive. That's why a revocable trust is worthless for healthcare planning purposes. So it's a restrictive trust. But yes, it can be used for home care planning. And before the change in law, when we didn't have to worry about periods of ineligibility applicable to home care, it was something that many people did. If you do it now, you got to be careful. Theoretically, if you do it now and you make your application before July of 2022, you'll be under the old rules and you'll be okay. That's what we understand from the Department of Health, but there's nothing written that's going to be true. So we have to be careful.
Thank you. Some more. Would Roth IRAs not in pay status with regular distributions be non-countable?
No, there's two questions there. The first question is, does a Roth IRA, which does not require minimum distributions, have to be in distribution status to be converted to an exempt resource? The answer to that's yes. Even if it's a Roth IRA, you have to put it into distribution status. I know the IRS doesn't require that, but for Medicaid purposes, it's still an IRA, even though it's a Roth IRA, so you have to put it into distribution status. Any distributions that you get out of a Roth or any other IRA are all going to be countable income, which brings us back to the pooled trust concept that we talked about before. If your income is too high, you're going to need to put some of that income into a pooled income trust in order to get Medicaid and keep your income available to pay household expenses.
If you put an heir's name on your home, does that protect it in probate court? And are they capable of selling the house without capital gains?
If you put, all right, let's try and break that question down a little bit. You can't just put well, if you do a deed and you make a joint with right of survivorship with a child, when you die, your child's going to get the asset. And in a case like that, there would be a step up in basis for half of the house, but the child would inherit that. If you do a deed and you give it to a child, but retain what's called a life estate, so technically you own the house and while you're alive, and the child has no current interest in the house. The moment you die, then the child owns the house, and that avoids a recovery for sure. It also creates a 5-year period of ineligibility. Either of these, whether you're creating a joint or use a deed and retain a life estate, will create a substantial period of ineligibility. There are also disadvantages because if you sell a house and you have and you've created a deed with the remainder interest and you've retained a life estate, you've almost certainly forfeited the 250,000 non-recognition of capital gains if you sell during your lifetime.
The next question is, are assets from your home, IRA, and in quotes, trust within will assets, all exemption under both community and institutional care?
Can you repeat the question?
Are assets from your home, IRA, and this is in quotes, trust within a will assets, or are all those things exempted under both community and institutional care?
Well, let's also break that down a bit. If you do probate, if you receive Medicaid and you do a will, what I was talking about before is if you have a will, and if I have a will and I have my wife as a beneficiary, and if I die, she gets those assets in trust. If she ever goes for Medicaid at a later point in time, all the assets that are in that trust that I've created under my last will and testament will not be available resources for her. Okay. That's what I was talking about earlier. If I have received Medicaid and I own those assets, those are part of my estate. And if I probate a will at that point in time, if I've received Medicaid, the Department of Social Services can put a lien on my estate and recover to the extent of Medicaid that I've actually received, dollar for dollar. So if I've received $100,000 of Medicaid benefit and I die with a house in my name and I've done nothing to protect the house, they can recover from the house if it is sold. The exceptions to that are if my wife is living there, they can't recover against it. If there's a disabled child living there, they can't recover against it.
We have a question. To avoid a 30-month look back, do you have to gift your money before July 2022?
Gifting it before July 2022 will not avoid the 30-month look back because we're now past October 1 of 2020. The problem is that, and this is all up in the air right now, the state has not implemented it yet. So even though I just told you that you have to worry about that, if you create a trust now and you fund the trust and you apply for Medicaid, and you apply for Medicaid home care, before they implement the law, you're going to be under the old rules. That's what we understand to be true right now, and that's remain true. Because the applications that we've been doing are being processed under the old rules. They're only asking for 3 months of information. When they implement the new rules, if I've made an irrevocable trust and it's after October 1 of 2020, it will create a period of ineligibility.
How do you find a village community?
Go Google village to village on any web browser, and you'll see the village concept appear. It's really an excellent program.
Someone's asking if there's a flat fee charge for setting up a trust, or is it an hourly charge?
Each lawyer does it differently. We charge an hourly rate, but they all fall within my experience is they all fall within a certain range, and I always tell them what the range is.
And the final question is, will this program be available to viewers later? Yes, it will. It's being recorded, I think, by Friday. Bruce, is that right? Oh, you're muted, Bruce.
Yes, it will be. And Neil, if you could take yourself off share for a minute.
Oh, I'm sorry. I'm sorry. Thank you.
Thank you so much, Neil. This was wonderful and covered a lot of territory, very, very informative.
Thank you. And Bruce, thank you.
Thank you. And thanks everyone for sticking with us. I know it was a little bit over an hour. I just want to take a moment to thank our sponsors. And I'm just pulling up the page here. You can see lots of law firms, including Cuddy and Heir, Neil's firm, financial planners, care managers, and others interested in the community and helping seniors. The last